Okay, good afternoon to everyone. It's a pleasure to see a lot of people on Friday after many discussion. And we know that you are here for this panel. Of course, before we want to make a sort of ritual to present the book coming from, this is the idea, and it was also the idea of our panel. So, as you know, we were involved in Gian Claudio and I and Gloria and also Gabriele that is not here in this commentary on the AI Act. And the commentary of AI Act is a very interesting experience, we can say. Not only a editorial experience, of course, but it's interesting because you realize the complexity of the topic. And at the same time, we realize also that it's very important to be very pragmatic. As I mentioned yesterday during Q&A, the academia should not stay in the ivory tower. We have to have an open discussion and to be realistic about what are the challenges and what are the problems and try to find solution. And this is more or less the perspective also of this panel. Because for us, it's quite easy to come and say, oh, everything is bad, the AI Act is bad, we want more rights protection, we want more many things, but it's useless, this kind of approach. We should be, to some extent, pragmatic, it's realpolitik, as you can call it, but we should be pragmatic because it's very important to contextualize this kind of act and this stream of regulation in digital society that, of course, there is a strong tension, internal tension, geopolitical tension, etc. So for this reason, our panel has an ambition to try to combine two different elements. On one hand, the high-level complexity. We know that behind the AI Act, there are geopolitical issues that are quite relevant and have an influence. But on the other hand, it's also important to look at what is the implementation, because we cannot spend a lot of time on the regulation and not talking about the implementation. And for this reason, we have combined this mixed panel. On one hand, we have Gian Claudio Maggieri that, with me and others, had the pleasure to dig in the AI Act, and also jointly we have also worked to have a better emphasis, we can say, on fundamental rights protection in the AI Act. But joining with us, we have also representative from the Commission, the AI Office, and also from the European Data Protection Supervisor. Why? Because it's important to look at what is the state of the art in terms of ongoing implementation. So to say what we are doing in concrete word. So what we are doing in the office, the AI office, in this case with Jordanka Yavanova, sorry for bad presentation, and that to know better what they are doing to implement the AI Act, but also the EDPS with Sonia Perez Romero, because the EDPS is implementing some concrete solution in terms of sandboxes and other exercises I don't want to anticipate. So it's important to move from an abstract debate to a very concrete and problem-solving approach. And to conclude, no one better than Gloria. Gloria Gonzalez is a friend since many years, and I'm very sure that his very critical approach will help us to better understand all the details. I share the same critical approach.
Bad reputation.
Okay. So let's start, and thank you to all the speakers for accepting our invitation, and I hope you enjoy this debate in the last day of the CPDP.
Thank you so much, Alessandro. Thank you for all of you for being here on after the last lunch of CPDP. Again on the omnibus, which actually in Latin means about all things. So you have heard a lot about the omnibus and a lot about all things. And now the occasion was to talk about this baby that was born a few weeks ago, actually 1 week ago. So this commentary took us a lot of caffeine and emails, but also 2 years of reflections, 2 years of exchanges. The challenge of the commentary was really to try to be manageable, handy in the practical sense, but also to cover this big ocean, which is the AI Act. So we summed up into thematic areas. So we tried. It's not an article per article, and we respect article by article commentaries. But some articles are less equal than others, to quote Orwell. And so we tried to put together the thematic areas. For example, measures for innovation, which is not a narrative that we might like, but it's the name of the section of the AI Act. Or prohibitions. Actually, for the prohibitions, we dedicated many chapters because even though it's just it's one article, it's Article 5, it's a huge effort to disentangle and great potentialities, great implications. And then I think the part for which I'm mostly proud about the book is the final part in which we try to do the impossible, and we are aware that this was just an approximation, but to do the links between the AI Act and other tools, other existing digital pieces of the digital rulebook. So we have a chapter that is by Gloria about AI Act and GDPR. Then we have a chapter about AI Act and DSA, AI Act and product liability. I see the author, Gianmarco Gori, in the audience. And we have AI Act and DMA, etc. So trying to link them together. Now, I think since this is a panel coming after many other panels on the omnibus, my attempt will be to talk mostly about what's not changing of the AI Act. So what's not in the omnibus, but what could have been improved. So what should have been actually addressed, and some tensions between indeed existing laws. But since we are now talking about this effort was about to look and visualize the AI Act. It took 2 years, and now this whole CPDP or half of it was dedicated to how a new AI Act will be. So I would like to say an anecdote. 5 years ago, Jordanka and I were sitting together in a panel, visualizing the future in a CPDP panel on Friday afternoon, visualizing the future AI Act. And now we are here, like checking the wounds. So what's happening? Of course, different roles, because at the time AI office didn't exist. It was the negotiator for the DG Connect, and now actually it's an implementation enforcement, let's say, unit on the AI Act. So a couple of points that I think need some epistemic power that is missing in the debate. One thing that I think it's very important, we dedicated a whole chapter to it, it's literacy. Now, literacy has been at the center of many discussions, and it's also within the proposed change in the final omnibus agreed trilateral document. Why literacy was always a Cinderella principle in the AI Act, but at the same time always named by everybody. I think, there are long answers and short answers, but I would say that literacy is genetically needed in the AI Act. Why? Because deployers and providers need to put in place a lot of technical duties and safeguards. For example, human oversight, just looking about high risk, they have human oversight, interpretability, data governance, and then there's the right to explanation. How can you as a deployer or a provider be able to guarantee these rights without having people that understand the AI system per se? And so this is just and there was a lot of criticism about the fact that literacy, Article 4 of the AI Act, is let's say a measure without sanctions, right? Now, for lawyers in the room, for legal scholars and legal thinkers, this is never the case, because even though literacy had no sanctions, like the lack of literacy duties has no sanctions, it can be anyhow used the lack of work on literacy as a means to prove negligence in case of a fault. So if you are not able to let your affected users exercise their right to explanation in Article 86, and in addition, you have no measures in place for literacy, I would say this increases the responsibility, for example. But this is just the superficial literacy, the technical literacy. There's much more that need to be done. And this is also a connection with many other discussions happening at CPDP about, for example, youth well-being, when they use chatbots, or when we use AI-driven systems in general. Literacy should not just be of employees of AI provider and AI deployers. Literacy should be also for users. And in particular, I would say it's not just technical literacy. We would need emotional literacy. So being able to understand what's happening when we chat with something that is ourself or that is non-human. And also legal risk literacy. Because and I think it's something that Article 4 does, also in the reformed version, to mention not just technical risks, but also, not just the technical literacy, but also being aware of the risks, legal implications of the AI. So what Mireille Hildebrand would call critical transparency. Now, the point, I think, is that, because now we mentioned awareness of risks, another, let's say, open bleeding spot of this discussion and of the book and in general the two omnibus is what to do with risk assessment, impact assessments. And this is Alessandro's territory, but we share the territory sometimes. But just to say that something very interesting and something that, indeed, as Alessandro said, we tried to be activist during the trialogue, as scholars, to say we should have a FRIA, we should have a better FRIA, and there are two important governments of Europe, Germany and France, who always were against and are still against, and they still tried, even in the omnibus, to delete last minute the FRIA. But the point is not just to have a FRIA, but to have a good fundamental right impact assessment. Yesterday there was a great panel about that on the fundamental right impact assessment. Something that we tried to do in the book was also to see the link between the FRIA and the DPIA, the Data Protection Impact Assessment, and also the DSA risk assessment. But there are more risk assessment. There's also the CSDDD, the Corporate Sustainability Due Diligence Directive, that has a risk assessment, and there are more, like environmental and so on. This is a good point to start with. There are a lot of practitioners at CPDP that are wondering about how to do impact assessment. And of course, this is something that cannot be solved in a panel, in a book. There are existing templates, and the omnibus proposed to have, was more the omnibus on data, not the omnibus on AI, proposed to have the templates and methodologies for impact assessment. I think we are always a bit skeptical when we see the word template, because it seems a great reduction of the problematic, of the socio-legal dimension of the problem, and in particular the social dimension of the problem. But I would say, looking at the history of the DPIA so far, it would be great to have something that can bring more brain energy to the project of DPIA, because the application was very basic so far. So this topic of risk assessment is also a tension that in the book we tried to have between the DSA notion of a systemic risk and the AI Act notion of systemic risk. Because this is also an interesting consistency exercise that we should do when we look at the digital rule book. Some terms are the same, they don't refer necessarily to the same definitions. And we don't know what the Court of Justice will do, but and Court of Justice gave us a lot of surprises in the last 2-3 years, so we will see. But usually, if you look at systemic risk in the DSA, the definitions that we have in the preamble, so in the recitals, doesn't necessarily match with the definition of systemic risk that we have in the AI Act. Because the AI Act looks broadly at safety, health, and fundamental rights, while the DSA focus more specific on the size of a very large online platform and their risk. So systemic in the DSA seems really a size problem, while in the AI Act seems more seem more a risk intensity problem, like severity. Then on this, we don't have answers also, and I hope maybe in the future better omnibus will do. I will conclude on another example, two final considerations. One is on the right to explanation, which was another point of tensions. So a right to explanation is not directly touched by the digital omnibus AI, but in a way there is a change, a proposed change on the in the digital omnibus and the GDPR, so the one that we will probably see approved, if any, in 2 years or so. And there, this proposed relaxation of Article 22. Article 22, now it's framed a right not to be subject to automated decision making, while in the proposed redefinition, they want to call it conditions for automated decision making, and to change the contractual necessity part as contractual purposes. So not necessity. Whatever you want, you have a contract, you can automate. I see the logic of having strong prohibitions, Article 5 AI Act, and then you say Article 22 is not anymore for prohibitions. But actually, I think this is a very brusque maneuver. And in addition to that, something that we should also emphasize is that the right to explanation per se had a very particular history. We didn't have a clear right to explanation in the GDPR, but so many of us were saying that there was. And with that in mind, the AI Act had a right to explanation. Article 86 was not the Commission proposal, was added by the Parliament and then approved, and saying, well, where somewhere else it doesn't apply, we will have a right to explanation in the AI Act. But then the Court of Justice came last year, 2 years ago, with the Dun Bradstreet case and say, yes, actually there is a right to explanation, and it's not Article 22, it's Article 15 of the GDPR. And then now what do we do? In the book we said this is a hydraulic effect, but the term, the credits go to my co-author Margot Kaminsky. The fact that the more water you have in one pile, the less water you have in the other. So the expansion of right to explanation in the GDPR is actually a restriction of right to explanation in the AI Act because of paragraph 2 and 3 of Article 86. But also in concrete, the scope is not the same, right? Because you might have cases of AI that are not under the GDPR, and you might have semi-automated decisions that might perhaps go under Article 6.3 and not, I'm sorry to use so many numbers, but because I don't have much time and all of you are all knowledgeable about the laws, and if you want more, there's the book. But just to say that this complex dynamics about semi-automated decisions and also the content of explanation is something very, very open for discussion. Last 30 seconds is about sovereignty, which is something that was also mentioned a lot today. So this the AI Act was had some possible consequences on sovereignty, we can say, technological sovereignty. There was a lot of discussion. There was all these narratives about the European champions. Don't get me started about Mistral and other bad stories of the negotiations. But I think that today the digital omnibus had also this nudge from the Draghi report, that was a report about innovation, but also sovereignty. I don't think this is where we are going. I think that with the digital omnibus in general on the GDPR and on the AI Act, what we are doing is to simplify the life for the bigger players who are usually based in the US or in China. And we are not actually, with that, solving the problem of smaller companies that might need to be rooted here. But this is not something that is the broader picture that Alessandro was mentioning, like the geopolitical dimension. I had this difficult task to address from cover to cover, and I decided to do like a leopard. But thank you for the panel.
Thank you, Gian Claudio, for trying to cover this entire book in a few minutes. If I might to take some points, I think, and it's also just to connect your comments to the comments that will come from Jordanka. I think that if you look at systemic risk, if you look at impact assessment, or if you look broader to the risk-based approach, that is the core, what is very important is, in the last part of the book, but in general, to have a coherent implementation of these tools to speak the same language, to have the same logic. Because outside this nice room, there are companies, there are public administration that have to comply with the AI Act, the GDPR, and many, many others. And we cannot imagine to have standards and approaches that are different. So as you mentioned, the systemic risk, there are some nuances, but maybe can be reconciled in a common approach, consider what is systemic risk. It's my favorite topic of research in the last months. But, and the same, the integration between the data protection impact assessment and fundamental rights impact assessment. All this is possible if we decide to also move from the legal framework to the implementation. Because then if the implementation, we speak different languages, and we have one model for data protection impact assessment, one model for fundamental rights impact assessment, one model for fundamental rights impact assessment under the DSA, and then there is again fragmentation. So the idea is also to look, like in this book, to the pragmatic and concrete sides. And for this reason, nothing better than Jordanka can tell me as about what is the pragmatic approach on the Commission about this topic, because she led the policy unit. That is a very critical point, I think, in this moment, also in the interaction between the many interests that are around, the political, company, and also civil society pressure. Thank you so much. Please, the floor you.
Yes, thank you very much. Indeed, very happy to be 5 years later again with some of the good faces and colleagues with whom we've gone through a lot already through the negotiations, but now also implementation of the AI Act. Indeed, it's been very much intense work, and we've actually grown a lot and achieved a lot. And now that's why really focusing first and foremost on implementing in practice and delivering what was agreed in the end with the AI Act, which is my current role. I know you've heard a lot maybe, and you've discussed so much on the AI Act. I've missed all other panels, and you've discussed also a lot on the omnibus. I don't know how best to use my 10 minutes that I'm given, but I just want a bit to outline maybe our role and what we do in the AI office for the implementation of the AI Act that is already there, existing. What are some of the changes that have been brought with the omnibus, and how overall this indeed is seen in the geopolitical context, and even what bigger impacts it can have beyond just EU, because I think this is what has been also overall the objective and very important role we as EU can play also as a trustworthy AI leader globally. So on the AI Act implementation in the office, indeed we were created, and we have huge role that is also combining both support the implementation of the AI Act, but also enforcement some of the rules, especially for the general purpose AI models, and also AI systems built on such models that has been now also a bit expanded. And we've grown a lot, and it is not easy to combine all these tasks and also to prepare for this future enforcement role, which is very important and will be the real test how the Act works in practice, because it's true, and it's so great to see so many different commentaries. We are facing ourselves daily with so many open questions indeed on many practical levels, both for the implementation of different provisions, but also interplay, coordination with other authorities, other enforcers, and all that is very important and takes shapes actually when you go into the actual work. And in parallel to that, we've been also, in order to give clarity and hopefully ensure consistent and uniform implementation of the AI Act, which is also very important, is to work on all these different guidelines, code of practices we've been producing in order to give the same common understanding and shape, but also do that in a very inclusive process, both asking for stakeholder feedback, engaging also very much with member states, national competent authorities, and all of you. So that's why it's great to continue all this dialogue together. And we've produced a number already of guidelines, very important. We've produced also, especially on the rules that are already applicable for the prohibitions. There are the guidelines on the prohibitions, and it's great now also to see how they are implemented in practice. or what further issues emerge as well, because they also matter a lot when you start to look at actual chatbot or an actual practice to implement the different aspects. And this is what we aim to do now, also in our collaboration with the member state and the AI board, where we combine all also future market surveillance authorities to work together and also ensure this exchange of information and common implementation. We also had the general purpose AI model code of practice, which was very successfully signed by many. And we also had the guidelines on which we continue to work as we move forward indeed with some of the implementation issues as regards the risk assessment, systemic risk assessments, for example, or others that now we have actually started to be receiving, and all of you can actually also see public summaries. So it's also very encouraging how the implementation works in practice, to see how openly all this information is also seen by you and can be further shared, analyzed, and we learn together based also, including on input from academics, including on complaints that now can be made also to future authorities. And we continue now, of course, also with the other rules. We have a code of practice and new rules on transparency of AI-generated content. Maybe you've all seen. We're so now working hard also to finalize it, as we aim to have it ready in early July. And we've also published draft guidelines, also on Article 50, and the consultation is open. So we will really encourage all of you to provide feedback on those. Next step is also, of course, to continue the implementation on the high-risk rules, which even if postponed with the AI Omnibus, in order to allow enough time also for development of standards, guidelines, and for companies to implement. We've also just published a consultation on the classification, what is a high risk or not. And we really invite all of you to provide input to that. And we, of course, continue to work on the development of the standards, pushing the European standardization organizations that these standards are delivered, providing also all of the other high-risk requirements, guidelines, and all the other implementation support guidelines that we have to do, or implementing acts for sandboxes to enable also innovation and already provide support to the companies, and either through sandboxes, but also launching other initiatives such as the AI Service Desk, to which also all of you and also providers and other deployers can reach out. So I don't want to continue, but it's indeed very important that we work collectively in all this effort, and we do that with the AI board and the strong cooperation with member states we have to ensure this common understanding, both in the guidelines we develop, but also in the actual work on specific cases. And then also, we've also recently just going to launch, after the successful calls for participation, but also the AI Advisory Forum, which will combine all different stakeholders that will further provide input to our work. And we've just also established the scientific panel. So just final changes for the Omnibus and a bit the impact and the relationship, how things, because indeed, being there initially for people being proud with the Act and seeing it as achievement, and they seeing indeed a lot over the, especially last 2 years, a big change in the narrative, and more focus on innovation, competitiveness. From our perspective, this is very important, because it matters a lot indeed that Europe stays at the forefront and we have effective implementation, and our organizations, deployers, we achieve both objectives, ensuring the safety, ensuring the fundamental rights protection, as well as the support for the innovation competitiveness. So these are not conflicting, but mutually supportive. And also with the Omnibus changes that were proposed, it has been indeed the main focus to tackle certain implementation challenges, overcome delays with the implementation, and ensure smoother interplay between certain different, both AI Act, but also other existing legislation. So that has been the main objective, and I think really the legislators managed to achieve, especially with the postponement of the rules that will now give us more time. But it's very important to emphasize that the core and the strength of the safety fundamental rights protections have stayed. And even if one look, we have even new prohibitions, as we see also that we need to keep the AI Act future-proof. We need to continue monitoring, and that really shows also with this new prohibition of AI systems generating child sexual abuse material or non-consensual intimate images, that also the EU co-legislators and we as EU continue to value a lot and strengthen also the fundamental rights protections. And indeed, we look forward to continuing a pragmatic, effective implementation of the Act, and we look forward for all your input for that. And we continue to also engage with international partners, also to make sure, and we see it also, that the AI Act, the GPI code, for example, has been replicated in US, in other states, or also similar legislative proposals have been proposed in other countries like India, Brazil, Canada. So even recently, Korea is looking for other aspects. So even if the climate is not necessarily really to move completely into regulation, I think Europe has really made very important step with the Act implementation, and we continue to influence a lot and to steer this debate globally. And as risks emerge and harm as well, we see also that political narrative can change. Thank you.
Thank you very much. Of course, we are victim of the changes of political narrative, and this is one of the rules of the game. And the political narrative is strictly related to the evolution of the global situation. But I think what you stressed, the European Union as trustworthy global leader in this field, I think is important. I touched directly my experience in Brazil advising for the new AI Act, but also recently in Armenia and Turkey with the European mission. There is a lot of attention for this country to look at what happens in Europe, because I think that one point that is very relevant is we do not export the AI Act for the Brussels effect that is overemphasized many times. We can export the AI Act because many countries are in the same position that we are. It means not having a very strong AI industry, and so, of course, be colonized by other services coming from other countries. And of course, you have to set some rules if the people want to play the game in your garden. And this is the logic. And this make the AI Act a political reference in many countries, including South America, North America, and Asia, etc. Just because it's an instrument to manage some industrial power imbalance that unfortunately still exists. And of course, in this sense, the effort of the office was a huge effort, with, as usual, with few people. And then we move to the DPS with Sonia Perez Romero, that is the head of Unit of Artificial Intelligence, commented with me the history of the unit in the last year, and it's a very similar story compared with the AI office. So as usual, we create the law, but then we take time and not enough resources to create those that have to oversight and implement the law. So I'm very grateful to you both and also to the staff of these two bodies, because regardless the opinions that sometimes we agree or disagree, but they are working in order to make impossible something that is very challenging, considering the limited resource that we have many times. So, Sonia, please, the floor is yours to know better what is the EDPS approach.
Thank you very much, Alessandro. Let me first congratulate you three for the book. It is already in the EDPS trolley to buy, so very, very happy that you have released that we have the academic coming from the ivory tower to also help us MSAs to fight these uncertainties and to navigate these exciting times. For those of you that know the European Data Protection Supervisor, we are not new. We were born in 2004 as a data protection authority. But since 2 years ago, we are 2 in 1. So EDPS is no longer the European Data Protection Supervisor. If you look closely, we are the European Data Protection and AI Systems Supervisor, which means that we have a part that takes care of the data protection, of the processing of personal data by institutions, and there is another part of the EDPS, the AI unit, that takes care of how European institutions implement the AI Act. And we are not mixed. We are together, but not mixed. So this is important for you to know. If we look even closer to this 2-in-1 authority, you will see that the AI Act is also 3-in-1. What is 3-in-1? Where we are the Market Surveillance Authority, which means that we look at the AI systems deployed and put into the market by EU institutions. But we are also a notified body, which means that we will approve those AI systems with biometrics that the EU institutions will develop with the time. It's not the case now, but I'm sure we will develop. This will happen like the mobile phones. Nobody knew about mobile phones until everyone has a mobile phone. So we will be looking at those biometric systems of EU institutions as notified body. And we are also members of the AI board, which means that we attend the AI board meetings and we participate, and we attend all the subgroups that hang from the AI board, currently around 15. Just for you to have an idea, the AI unit is 13 people. So we are outnumbered by the number of subgroups of the AI board, which is one of the 3 things that we do. But well, it has been quite a ride since October 2024, when the AI unit was created with 0 staff. So in 1.5 years, we've grown by 12, not bad. And we've done quite a few things that I would like to explain to you. And for those new market surveillance authorities, or those that will be born in the future, because the EDPS was born with the AI Act, we are directly appointed. We didn't need any government to appoint us directly, just the AI Act was created, and boom, there we were. So we have been the pioneers for that. Here is the 3 lessons that you need to learn from our experience in these 1.5 years. The first one is cooperation is crucial. We have Article 77. In the case of the EDPS, we have 3 fundamental rights authorities listed under the cooperation provision of the AI Act. We have the European Ombudsman, we have the Authority for Political Parties and Political Foundations, and surprise, surprise, we have the EDPS. So we cooperate with ourselves in the 2-in-1 authority. And this means that we need to have formal cooperation procedures that are also available for the other 2 fundamental rights authorities with which we cooperate. So that is the first challenge. But even more important than cooperation across regulator, because we will manage that, is the cooperation with the supervised institutions. This is crucial if we want to get the AI Act right. And what have we done from the EDPS to get it right with our supervised entities? We have encouraged the EU institutions to appoint the AI Act correspondent. This is a person directly appointed from the boards or from the secretaries general to be the responsible person for AI matters in the institutions. This means that you already have role attributed and you have a person responsible for that. And this person is directly talking to the management because it has been appointed by them with their trust, but is also entitled to talk to the operational part. So it's rolling out messages. So it's not our messages, it's not a contact point from the EDPS. This is the person responsible, trusted by the management of each institution. That's the key in this figure. And now this person, of course, talked to us, and with a team of 12 people and able to oversee 87 institutions that have now AI in their organizations. How do I know that they have AI in their organizations? Because we have AI correspondents, and they told us. How did they tell us? Well, we did a mapping of AI systems in the EU institutions, which results are public. So check in our website for the mapping on AI system of EUIs, where you will see what kind of technologies the institutions have, in what kind of areas we have them, and what are the status of those technologies. Are they in development? Are they deployed? Are they thinking about acquiring this from off-the-shelf solutions? So this was the second thing that we did through this cooperation with the supervised. We know our ecosystem. And the third thing we did by cooperating with the supervised entities is to leverage on them. Of course, if they have the means that you don't have, then you leverage on them, and we offer a pilot project for an AI regulatory sandbox. We call it pilot project because, as you know, Article 57 on sandboxes is not yet into force, so necessarily it needs to be a pilot. But we are learning very, very, very much from two sides. We are learning how to offer in the future a sandbox, because so far there is no sandbox because there is no Article 57 in force. So we are now getting the lessons for the future when we have to apply it to get this right. And we are showing to the supervised entity that they can make it. We are helping them to understand what we expect in the future when we go to audit them so that they are ready. There's no surprise here. We tell them what we want, we do it with them, and when we go, they have it. So that's fantastic from the governance point of view. So we need to cooperate with the supervised entities. Second lesson learned. AI literacy is the basic of everything. It's the basic of governance. That's why we have AI correspondents that we train twice a year in our own events to tell them what they need to be updated on and what they need to follow. So AI literacy from the governance point of view, AI literacy from the user's point of view. Thanks to our AI correspondents, we have been able to roll out the Commission's packages on AI literacy, and we have requested what we call the driving license for AI, so that everyone in the EU institutions, no matter whether they are desk officers or managers, they are trained. So the AI correspondents are in charge of telling the HR people to roll out those trainings that are available thanks to the Commission, so that everyone gets their driving license. If we're driving AI systems, we're getting driving licenses. And the third part on this AI literacy is to demystify the AI Act. When we started this journey, many people came in the first AI Correspondence Network to say, we know that you don't want us to adopt high-risk AI systems. No. I want you to adopt high-risk AI systems. High-risk AI systems are those areas that are important in life. Recruitment, critical infrastructures, health. This is the important part where we need AI to help humans to do it, but we need to get it right. So I want you to adopt trustworthy AI, and I'm going to help you do that. So let's demystify first high risk, and let's demystify that AI Act is difficult. If you get the people rightly appointed with the right responsibilities in your institutions, then let's work together to have this compliance. And of course, recycle Professor Malgeri was talking about the intersection, DSA, DMA, GDPR. There are myriad of already regulations that you have already complied with. Just bring this to the AI Act world, connect them, and you have half of the work done. But we need to work together to do that. So that's the second point on AI literacy. The third lesson learned is, if you are an MSA, get your plan. What is our plan? You need to read the EDPS Compass on our role as AI Act authority. This is in our website, so look for EDPS Compass, and you will know what is the plan of the AI unit, what is the plan of the EDPS for the next 2 years, and how we intend to do that. I will stop here because I don't want to take too much of the time, but I thank you again.
Thank you. Thank you very much, Sonia. I think that it's very important what you say, because first, the EDPS is personally my dream as institution, because combined data protection and AI, it would be standard model. Unfortunately, it's much more complicated in many countries, including my home country, complicated for many reasons. The second point is the role of correspondence, that at EU level, you create an important role that should be also something to be implemented in many other more granular institution and reality. Because while in the GDPR we have the DPO, in the AI Act we have not equivalent of the DPO. Now the DPO are acting as a sort of AI expert, but this is a real problem that we have to see also in impact assessment in real cases. We need internal references, people that can create this kind of bridge between the regulators and what is the daily life, we can say, in each organization. So although not in the regulation, it will be important to implement in a de facto manner, we can say, this kind of figure, because it's very important, because the people are not aware. And the AI Act, maybe in the, even more so in the field of fundamental rights, is very complicated because the people are not familiar with fundamental rights. And the last point, support and pilot. So support and also testing is very important to test what you want to put in practice, because on paper, everything works perfectly. It comes from the university. We publish paper, we read paper. I've seen some very nice, complicated risk assessment model that works just on paper. It's impossible that you can implement in real world. And so I think it's very important to start with pilot, also because pilot can bridge this sort of concern about the AI Act. So, oh, it's difficult. No, it's not difficult, because the AI do that, this is the pilot, this is the result that was achievable. So we need to move from the abstract to the concrete world, I think. And this solves many of the doubts, or also false doubts, that we have about the AI Act. And with this, all these stimulating points, the last words is to Gloria.
Thank you very much. Hello, everybody. I'm very impressed to see so many people here at this time. I thought you were all fed up with the panels, but not yet. And I will first try to be a bit critical with this idea that I'm critical. I'm not critical. I'm as constructive as I can be. And I'm very happy to be here because so one of the reasons why we have this panel is really the idea of promoting this book that Gian Claudio is discreetly trying to put in all positions while speakers talk. I hope you have seen this. I'm a proud co-editor of this book, and yes, but I have to tell you a little secret that our publisher doesn't know and my co-editors don't know, but I think it's only fair that I tell you, and then I tell them now that you're here to protect me, because the thing is, before I agreed to co-edit this book, I had been offered the possibility by another publisher to co-edit or to edit a book about the AI Act. And I thought, ooh, is this a good idea? So I had a moment of introspection. Should I do this? Should I not do this? And I thought, well, maybe, and this is, please don't get offended, don't take it personally. I thought if I had to co-edit a book about the AI Act, it would be very nice to co-edit this book with, because I'm a legal scholar, it would be very nice to co-edit with a computer scientist. I thought that would make sense. So I have to look for a computer scientist that wants to co-edit a book about the AI Act with me. So I contacted one, which was basically not the right one that I should have contacted, because he said, yes, we can have a little talk, but then he said, listen, in my view, something like this, nobody is writing anything anymore. People are just using AI, and nobody is reading anything anymore. So it's like, no, I'm not going to write a book about the AI Act, because nobody will ever want to read a book about the AI Act. And I thought, okay, and I had to break the news in a subtle way to the other publisher, and I try not to tell her, like, no, people don't read books, don't write books. I found an excuse, and I tried to forget about this, and then I received an email by Gian Claudio. Hello, we are co-editing a book about the AI Act, and I thought, well, maybe if there are some humans in this planet crazy enough to think that we should all start to still write something meaningful about the AI Act, and people will maybe want to read something that we have written about the AI Act, maybe we should be friends with these people, and I'm very happy that I embarked this project, and I'm very happy that our publisher also still believes in this, and that, yes, we can sell these copies to you, maybe. So this is the little anecdote. I've been co-editing this book. I've been, since the AI Act is there, reading a lot of commentaries about the papers, master theses, many, many things of people writing about the AI Act. And actually my feeling is that we all try to be constructively critical, and we all try to convince ourselves that it makes sense. And normally if you receive a text about anything about the AI Act, you can take any chapter, you will see that it starts saying, well, it makes sense that we have some rules about this because blah, 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 blah. All makes sense, but indeed there are some provisions that suddenly make less sense. And this is what I call these provisions. So I hope I suppose we have some AI experts in the room. There is this document of the Council which shows how the text was supposed to be and how it was adopted by the legislator after these 2 days or 3 days of negotiations. And everything that was changed at the end is in bold in italics. I don't know if anybody knows what I'm talking about, but there is a document that shows this is what we thought this would be, and this is what was there in the end. But this is the part that we are all struggling with, and we could have a half a book, which everything will be much clearer. So this is actually a real thing that happened. In the end, there was a sort of rush to get this approved, and it was there. Maybe there was some good reasons to be in such a hurry. We wanted to be number one. Europe. Maybe it was very important that this was approved because it's important that we are all protected. Now, in retrospect, when we know that actually now many of these rules have been postponed because there's less of a hurry, it's perhaps a bit more complicated to understand why was it so important to get this deal in the late hours of the morning and get all this weird content that was then adopted. This could have been all sort of fine, except recently, last week, 2 weeks ago, I wake up in the morning and I see a little news item in the late hours or the early hours of the morning. The legislator has done it again. They have agreed on the omnibus on the AI Act. Then we have to read it. I didn't read it immediately, but I really, so it's a half a joke, but really a serious. I really wonder why, if you ever know somebody who is in this kind of rooms when things are negotiated, and I'm saying this for a friend, I'm saying this for the GDPR, and for the day where this will be, the omnibus on the data will be finally agreed. Tell people Brussels by night is beautiful. After midnight, you can just go have a walk. Tomorrow will be another day. Think maybe take the time to think about what you're agreeing to. Because what was the hurry now, really? What was the stress? Did they really have to agree on whatever at 4 o'clock, 4:30, they said in a press conference as like teenagers, I really don't get it. I really don't get it because it's not that they were having fun, it's that it's about our fundamental rights. So then one tries not to be too critical, but then still when you read it, there are some things that you wonder, why was this like this? If I still have a little minute just to say something about them. So do I have any problems now with the omnibus for AI? I have some. There is one which is about the subject that I've been writing about in this book, and that's the relation between the AI Act and the GDPR. And I really, really made an effort to convince myself that the AI Act as such was not such a big drama for the GDPR. I thought, well, you can see that actually there were indeed people in the room who understood the GDPR contrary to what happened when the Data Governance Act was written, that clearly there was nobody who had a clue about the GDPR and it's all a mess. But for the Act, they made an effort to actually make sure that it sort of fits. And I try to explain to people, well, the GDPR is there. The GDPR leaves some doors open that can be open if you want to encourage further processing. And the AI Act opened those doors and said, well, for instance, if you need to, you want to reduce bias in AI, you can do this and that. Now, the new version that we are now about to have about the AI Act, I'm not sure really just open doors. It has taken one of these doors, it's really unscrew the door and threw the door out of the window, because now it's sort of proportionality goodbye, and this is so that we have this sort of limited possibility to process sensitive data to mitigate, detect a bias, which is in itself, I have to insist, a very strange idea, because remember, we have AI that discriminates in general, and if we have it, it was never the fault of the GDPR. It's not because GDPR is very strict on sensitive data that people cannot have better AI. The proof is that typically AI discriminates based on gender, and gender is not even a sensitive category of data under the GDPR. If that was really the problem, we could have non-discriminatory AI for decades. We don't have it, not because the GDPR is there as an obstacle, just because we don't have it. So now they said it's very, very important that we change the GDPR so we don't have discrimination under with AI, and therefore we just allow the use of sensitive data on a massively whenever you are developing AI, if it's high risk because it's important, but also when it's not high risk, in general, go and process sensitive data. And if I can misquote somebody, if you think that by giving up the protection of sensitive data, you will get non-discriminatory AI, you don't deserve anything at all. I think you deserve everything, but you will not get non-discriminatory AI, and you will just not even get any more a GDPR that can protect you when you are discriminated. So it's a whole big issue. That's all for me. I wasn't even critical.
Thank you very much. No, we are not critical, so I'm not so happy. But now I give the floor to the audience. If you have any question to the speaker with regard to the different topics that we discussed, yes, please.
So when the AI Act was negotiated in December 2023, the underlying intent was clearly to cover what is called the frontier AI models, for GPI models. And GPI models actually entering into force now, the fines are and everything a second ago, so it was not delayed by the AI Omnibus. But now we have the Chinese models, which are extremely performance, very good, it's dramatic, completely changed the situation when the AI Act was negotiated. So I was wondering, how are we going to play this out?
Okay, I think if that was Peter was looking at me, and we've been actually, by the way, with him negotiating in these famous nights as well, because he was working at the time in the parliament for the trilogues. But to the question, I think clearly the Chinese, or regardless of where the models are produced, are covered. And even also open source models are covered. This is also very important. So from our enforcement perspective, Chinese companies have not been signatories to the code. But that doesn't mean that we'll not enforce. On the contrary, the way we promote also our codes is that, yes, if you are a signatory, you have more trust, you have more transparency, how you take forward compliance. And you can rely, but if you are not, that means that that will likely lead that we'll need more information from you, and will require more adequate assessment of what other measures have been done. So just to reassure you that we look very much also on non-signatories to the code, and on also enforcement on also open source models, also provided by Chinese. And this will kick off also in August, when our enforcement powers will start, but we are already in dialogues with many of these providers who also want to take compliance already into account earlier.
Any other question, please?
Hi, I'm Helena. I'm qualified lawyer in China and in England, Wales, and I did my PhD in the UK. So in terms of the geopolitical tension, I feel a little bit targeted. But anyway, I have a question. Raised by two or three evil countries, right? After Brexit. Yeah. So I have a question about the right to explanation. So currently, America and China have been adopting the quite similar approach. So the United States doesn't recognize the general right, federal right to explanation in AI regulation. Instead, explanation like rights arise in a fragmented and sector, specific manner, particularly through adverse action notice requirements in credit law, in investment law, consumer rights privacy, mostly in California, and emerging state-level regulation of automated decision-making. So there's no general right to explanation right in the states right now. Of course, California and Colorado have been trying to, I would say, refer to the EU approach. In China, as a Chinese citizen, sorry, I have so it's like the right to explanation, the very like EU approach had already existed in certain, I would say, like Chinese laws, more specifically under the Article 24 of the Personal Information Protection Law and the provisions on the administration of algorithmic recommendation in Internet information services. However, in generative AI part, China doesn't recognize the right to explanation. I mean, at least not as in the AI Act in EU. I would say that, of course, I would say that the civil law lawyers and AI data regulation scholars in China, they have been trying to, cite and learning from the AI Act to better to implement or create right to explanation the EU approach. Do you think this can preference this trend? Of course, in America, investment industry is the core of the American capitalism, right? And in China, do you think this at least the previous reservation of not recognizing right explanation in generative AI has something to do with the geopolitical narrative or their preference? And probably in the future, do you think there's gonna be at least some elbow rooms for, the AI industry, big countries to learn from the EU and to better, regulate and protect the rights of the users?
Thank you so much. Great points. Maybe the short answer is also Europe doesn't recognize right to explanation for generative AI because Article 86 applies just to high risk cases, and the high risk in Annex 3 are all automated decision systems, not generative AI. So, and this brings me to, you give me the opportunity to open a small parenthesis about one of the biggest frustrations that I have at the moment, which is the chatbots. Generative AI chatbots are considered limited risk. This is a joke. It's a big joke. And if you have to reform the AI Act with the Digital Omnibus on AI, this is the first thing you should do. Many countries are regulating chatbots, and Europe is saying it's limited risk. Then, of course, we have other laws and tools that can help. If OpenAI becomes a very large online platform, we have the DSA. Then we have GDPR. And anyway, several rules apply anyway, we have general purpose AI regulation in the AI Act. So just to say that right to explanation doesn't apply to, let's say, what broadly speaking is general purpose AI, but applies to very specific cases in... Sorry? Yeah, it can apply if general purpose AI is used for cases of Annex 3, like trials at the emergency room or insurance, whatever. But just if it's public bodies doing it, or bodies with or banks or insurances. And there we could wonder why. There's a political reasons. It was restricted because it was she doesn't agree, but also a science reason, like it might be easier for these companies to provide right to explanation, while for parties that are not, like very private entities, this is not the case. But maybe a more general message between comparison between Chinese data protection law and rights, the Americans and European. I think it's very we have indeed to break the taboo that the Chinese law is not to be looked at. I think there are a lot of interesting sources there, and Chinese law is much more than US law for the protection of many digital elements. I think we disagree on the basis, but on the technicalities there's much more alignment. Of course the basis has a big difference, like the idea of fundamental rights and the idea of also how we visualize fundamental rights. But I think Jordanka wanted to say something about the actors of the right to explanation, Article 86.
Yes, I just wanted to clarify that it does apply also to private actors.
If they are public functions.
No, this is the limitation for FRIA. As regard to the right to an explanation, it applies to both public and private.
Sorry.
Whenever there is a
risk,
decision for serious consequences. So, and that another, as regards the chatbots more broadly, while it's true that they are not in general a high-risk category, the different rules always apply to them as well. They always need to, for example, people need to be informed when they are interacting directly with the chatbots, or the prohibitions of manipulative, exploitative AI still applies, or scoring. So still the other aspects apply, and it is indeed now we have to look at the future. It's one of the topics for different also applications, what kind of risks and what kind of best treatment is needed. But indeed other legislation already provides certain protection, including as regards, for example, the general product safety or GDPR. So but that's certainly one of the topics we are looking.
Just 30 seconds. It's true. I was mentioning FRIA limitations, but we were talking about the right explanation. I'm tired. But just to say one more thing about the labeling. So limited risk means that you have to tell this is AI. Yes, the case of the 14-year-old guy who took his life in the US, he knew very well that was AI, because in the chatbot he says, "Oh, I know Daenerys Targaryen, I'm character AI. I know you are AI. I want to reach you, so I will take my life." He knew very well that was AI. So I just say labeling is not the solution. It's not your fault, of course. Just we can improve the law.
If I may, if I may, with the case of the chatbot, it's important. I investigated. The problem is Article 5. So you can use in this case the prohibition, because these are clearly manipulative chatbots. There are evidence in the case decided by United Nations, and also in the case under scrutiny by the court in United Nations, in which there are clear manipulatory design that is relevant in terms of prohibition under the Act, and is more relevant also under other regulation in Europe in terms of responsibility, we can say. So I think there is an alignment, and if it's true that we have some significant disagreement with the Chinese regulation as concern fundamental rights, for instance, I think that with regard to the child rights, there is a common position in terms of protecting a young generation. I think on this is an important venue for discussion and to collaborate also at global level on this topic. And the last point before the question on the back, of course, we pay the cost of deciding to have a first generation law in AI very focused on classification. This is not GDPR. GDPR, there is not classification. We decide what is high risk and what is not high risk. Was a clear decision for policymaker in order to facilitate, we can say, the first regulation. But of course, the classification that fit very well with something that is very frequently transformative and changing. So in the long run, probably this will the pillar that will be reshaped in the EU regulation. There is a question here, and then there, last two. Yeah, we can collect together the two questions. Yeah.
Okay. Hello, I hope you can hear me. I am Salan. I'm writing my PhD on the question whether the AI Act protects against gender discrimination. And I have a kind of critical view on this topic. And during the CPDP and also during my research, I always read and hear that we have to make the AI Act work as it is and the FRIA work as it is. But I would like to kind of challenge you with my question. In an ideal world, what would you change about the AI Act? Because in my opinion, and also in my PhD research, I am thinking that it does not protect us from gender discrimination and also other discrimination as it is right now, but also AI tends to create new discriminations which we are not aware right now, and will we do have this kind of black box, and it will continue creating new patterns we do not know of as human beings. And yeah, just like a critical question, what you think would need to change in an ideal world if we could change the AI Act, because I am not satisfied by how it is right now.
Thank you very much. You take the other one, Jean-Marc.
I stand up because I can't see you otherwise. I would like to ask a question about what looks to me to be a bit of a blind spot, but I really hope it's not. And it is when general purpose AI systems are used by consumers, natural person, for high risk purposes, but also by administration. So instead of developing, placing on the market, or putting into service a high risk system, or be deployer of that, I can just use ChatGPT. What happens at the point? Who's the provider? Who's the deployer? Article 25 establishes that changing the intended purpose of also a general purpose AI system in a way that makes it high risk makes me the provider. But if I use systematically ChatGPT for that purpose, am I the provider? And who's going to enforce? The Commission? Thanks.
Okay, maybe for the first question we can address you both if you like, and the last maybe is more technical.
What is this? This is gender discrimination, no? Yeah. So I will say we will change the moderator. Anyway, no. So what I will change personally, very quickly in the AI Act, facial recognition in the streets by the police, get rid of that. Now it's prohibited but allowed. No, or you prohibit it, or you just don't mention it, but you don't legalize it as it now. In relation to gender specifically, there is this huge problem with biometric categorization. It's all a mess, so that should be clarified. And specifically, I've been really brainstorming with many smart people. Is the attribution of gender allowed or not allowed? Is the use of gender as a sensitive category attribute? There is an ambiguity at some point with what is the sensitive attributes that you cannot use to do the categorization. Half of the survey people think gender is part of that. Half of the people think it isn't, and it's very, very ambiguous. So for gender, indeed, there are too many ambiguities. Specifically, the idea that you can assign a gender to somebody automatically, it's not taken seriously, and it's a huge, huge problem for the fundamental rights of many people.
Thank you.
Yes, maybe very briefly on the 2 points. I want to say that the relevant guidelines that are now under consultation can be quite useful for both of the questions that were asked. As regards, for example, exactly the question that Gloria raised for the biometric categorization, whether it's high risk or not. But I just want to emphasize that also this consultation have another very relevant question, which is whether we need and we are obliged to do this annual review. By the way, we just published yesterday the report of the last year review for whether we need to amend in the future the high-risk use cases or the prohibition. So that's why we have so many reports, guidelines, and things to do. But this consultation that is now open on the high-risk guidelines also have specific questions for that. So you are very welcome to provide input on whether more broadly AI Act does anything for gender discrimination. So in addition to the biometric categorization, I really want to emphasize that all the safeguards that we have for high-risk systems, they do aim to prevent discrimination in terms of the bias, data quality, bias detection, and mitigation measures in terms of the additional quality testing, risk assessments that are to be done, documentation, conformity assessment processes, and this is already before the system is put in place. FRIA plays a very important role. So really, for the high-risk use case, I really encourage you to look from that perspective what the AI Act can do. And okay, it is what it is with the risk-based approach. Not everything is high risk, but then that's why we have the list that can be amended, that can be informed with more evidence, and we rely then on all of you to help us if such amendments are needed. So the other question that was asked for how we switch the roles and what happens if we have a general purpose systems then that might be used also for our high risk use case. The same guidelines on the high risk classification have in the first part something that explains how you have to interpret the intended purpose and what could be already the original provider's responsibility, because you could have broad, broadly defined the intended purposes, and in certain cases, even when the system can be used for high risk, it could be already covered by the original provider. Then it's correct that when the provider has narrowly defined, and then when there are also restrictions and the system cannot be used for certain high-risk cases, like if you have just a general chatbot, and this is very clearly excluded, then it's true that then the user always remain responsible when they go beyond, and if they start to use systematically AI for professional purposes and for the high-risk use cases for employment, because all these use cases are broadly defined as more professional uses at the moment, it can be still covered. As regards the prohibitions, even if it's non-professional purposes and use cases, and if you start even now to generate, for example, some use manipulative and for harmful purposes, and there are also clarifications for that this could be covered under the bans.
Thank you you all for your experience, for your comments, and for addressing the questions that are a lot on this topic. And we have seen also how it's complicated to deal with a topic that is evolving, so you can imagine how it's complicated to write a commentary. But last point about the book is thematic, as mentioned by Gian Claudio, and thematic is exactly that. We want to focus on the main pillars. Of course, there are fine-tuning regulatory exercise. Sometimes this regulatory exercise can touch some part of the AI Act, but we are convinced that the main blocks remain the same. For this reason, we decide to focus on thematic, so the main theme. And then, of course, we are aware about the ongoing new approach of EU regulation, so continuous evolving, that give us as academics a lot of room for reflection and writing. And for this reason, we have complemented the same book with an online website in which we can continue to exercise our writing activity in line with the new feedback that we receive not only from the regulator, but I hope more from the implementation, because I think it's very important that they look at the implementation, not just on the change of the regulation. The real simplification is in implementation more than in regulation. Thank you very much.